Hi everyone, and welcome to another edition of the Community and the Law platform. This is a very short video summarizing what we've been discussing this afternoon on the show. So we've been looking at how debt to the NHS could affect your immigration application, whether within the UK or if you're applying for a visa to come into the UK. Normally, if you're coming into the UK for anything below 6 months, you're not required to pay what we call the immigration health surcharge. If you're coming beyond 6 months, then you'll be required to pay the immigration health surcharge as part of your application. There's a tendency of visitors coming in and then using our health care facilities and sometimes not paying for the cost that is incurred. Now, there are two categories of healthcare that you can obtain here in the UK. So there's the primary healthcare and then this is the secondary healthcare. The primary healthcare normally would not incur any cost as such. And so even if you're here on a temporary basis with a visitor's visa or a visa which is less than 6 months, you would be able to access a healthcare facility for a primary healthcare. So your usual headaches, your usual aches and pains and all of that would come under that. And say if you're prescribed a medication for your medical issue, then you would have to pay for that prescription. That aside, if say for instance you attended a health facility for a secondary health care, then you may incur cost. It is not always the case that you attend a medical facility, i.e. a hospital, for a secondary care that you would incur a cost. So for instance, during the COVID period, if you were here as a visitor and you unfortunately got infected with COVID and you went into a hospital, you would not incur a cost for that. If you're suffering from a TB or any viral infection and you went to a hospital and you were a visitor here, you would not incur any cost for that either. But then say, for instance, you come here and you were pregnant and then you went into any of the medical facilities and gave birth and you didn't have leave to remain, which is indefinite or settled, or say if you were not somebody who was here as a person who is ordinarily resident here, then you could incur cost. And if that cost is not paid to the NHS, that could affect your application for leave to remain in the UK or subsequent application for leave to enter the UK. The Home Office have the discretion to refuse that application if there's a NHS debt from the tune of 500 and above. They have the discretion to refuse your application if it comes to their notice. And this is how they get to know. Once you are applying, they will ask you the question whether or not you've used our services in the past and had incurred any cost and you didn't pay. They can also ask the NHS for the same questions, whether or not there's any cost that you're owed to them, which is not being paid. And once they have that information, they may decide whether to reject your application or not, or to refuse your application or not. So yes, there's not a statutory definition for who is ordinarily resident here in the UK, but there's a legislation under Section 39 of the Immigration Act 2014 that basically tells us who is not here as somebody who is ordinary resident here. And that would include those who are here as visitors. So if you're here and you have indefinite leave to remain, you're settled under the EU settlement scheme, and you are a British citizen, you would be classed as somebody who is here as ordinarily resident here in the UK. Now, with EU nationals as well, if you enter the UK before even Brexit, you'll be classed as somebody who is ordinarily resident here. There's a case law called 𝗖𝗢𝗠𝗨𝗡𝗧. And since the Brexit, the law is being amended to include this in the 2014 Immigration Act. So that Section 39 is being amended to incorporate EU citizens and their family members. And so with EU nationals, if you were here before the deadline date, which is the 31st of December 2020, then you would be classed as somebody who is an ordinary resident here. And that is irrespective of whether or not you've been granted settled status or not. And your family members who would subsequently join you would all be classed as ordinarily resident here in the UK. Now, back before 2016, you would have to incur a cost of 1,000 and above for the Home Office to consider refusing your application on suitability grounds. The law is changed, and so since 2016 April, it has to be beyond £500 for the Home Office to consider whether or not to refuse your application. So bear in mind, if you have any debt at all with the NHS, don't bury your head under the sun. You can always speak to the NHS and arrange a payment which is reasonable and that is affordable to you as well. You can come to that agreement. With that, you can always demonstrate to the Home Office when you make your application that even though you've incurred the cost, you have not pushed the cost aside, but then you are making the effort to make payment towards that cost. And that would basically get you off the hook when you apply for your visit visa in the future, or you apply to come and live in the UK permanently. So this is what we've been discussing. We hope this is going to help you, and it's going to help friends and family members as well. What you can do is pass it on to others who have not yet come to know us, so that they also get to know us, that we're here every weekend discussing UK immigration law and other areas of UK law. Join us same time on the same platform next week, BWF Solicitors and all of the other platforms. If you want to come to see us, we're 4th floor of the Anna House, N15 4NP on the High Street of Seven Sisters. Seven Sisters Underground Tube is the closest station to us. Exit number 2 is what you want. And you can contact us on 0208 493 7340. 0208 493 7340. Thank you very much for listening.